Good morning. Welcome to today's meeting on the Assembly Committee on Government Affairs for the 2025 legislative session. Will the Secretary please call the roll?
Assembly members Carter.
Present.
DeLong.
Mostly here.
De Silva. Edgeworth.
Present.
Flanagan.
Here.
Gallant.
Here.
Goulding. Gurr. Hunt. Jackson. Karras. Kasama. Wynn. Chair Considine.
I am here. Would you please mark Assembly Member Goulding absent excused? And welcome to the audience here in Carson City today, anyone in Las Vegas via video conference, and anyone listening over the internet. I'd like to begin today with some housekeeping measures. First, please check and silence your electronic devices. If you are planning to testify, please sign in at the table by the door and provide a card to our committee secretary. When testifying, please turn the microphone on and clearly state your name and any affiliation for the record. If you are providing handouts, please ensure that hard copies are available to members of the public. Electronic copies should have been submitted to our committee manager by 9 a.m. yesterday for committee members. We expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. And as always, I encourage committee members to ask questions, engage with the material presented. If you have any follow-ups, please flag them for me so we can ensure to balance our time effectively during the meetings. And committee members will be using their laptops to view handouts and other documents. Please do not interpret this as a sign of disrespect or inattention. Today, we will conduct a work session to take action on measures the committee has heard in previous meetings. After that, we'll hear 3 bills. We'll begin with Senate Bill 285, which revises provisions relating to apprenticeships. Next, we'll hear Senate Bill 319, which requires the Washoe County Board of County Commissioners, Reno City Council, and Sparks City Council to establish a board to study the creation of a county fire protection district within certain territories. And finally, we will hear SB 340, which revises provisions relating to governmental administration. I will now open the work session. It is not customary for the committee to take testimony or rehear the bills during a work session. However, I may invite a witness to come forward for clarification or questions during our consideration of a measure. We will be hearing 5 bills during the work session today. Senate Concurrent Resolution 2, Assembly Bill 188, and Senate Bills 15, 27, and 358. And with that, we'll get started. And we will begin with SCR 2.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. As nonpartisan legislative staff, I can neither support nor oppose any measure before the committee. The first bill on work session is Senate Concurrent Resolution 2 in its first reprint. The committee heard this measure on May 1st. Senate Concurrent Resolution 2 recognizes the Fruit Loop as a historical LGBTQ+ landmark in Clark County, Nevada. The resolution urges the Director of Nevada's Department of Transportation to install directional signs to direct tourists and members of the public to the location of the Fruit Loop, which is located where East Naples Drive meets South Paradise Road and South University Center Drive in Las Vegas. Finally, the Las Vegas Convention and Visitors Authority and the Division of Tourism are encouraged to produce materials concerning the cultural and historical significance of the Fruit Loop for inclusion on maps and other marketing materials. Senator Danyate proposed an amendment to add Assembly members Considine, De Silva, and Wynn as joint sponsors to the bill. Thank you, Chair.
Thank you. Members, are there any questions? Seeing none, I will now entertain a motion on SCR 2.
So moved.
Motion to amend and do
Second.
pass. Amend and do pass motion made by
Move and
Vice
amend to do
Chair
pass.
and second by Assembly Member Carter. Is there any discussion on the motion? Are you holding your hands up for discussion, Assembly Member? Yes, please go ahead.
Thank you, Chair. Sorry I wasn't clear to begin with. As I said during the hearing on this resolution, I have concern about putting into state documents what I believe is a slur to gay people using the term fruit, and so I will be voting no for that reason.
Thank you. Is there any other discussion on the measure? Assembly Member Kasama.
Thank you, Chair. I'll be voting no. I'm fine with the historical significance, but I really believe we should not be voting on this as a mistake. I think this should be Clark County or City of Las Vegas, just like if Reno or Elko wanted to designate a certain area. I don't think this should be on the state level. I think that should be local. Thank you.
Thank you. Is there any other discussion on the motion? Assemblymember Gur.
Thank you, Chair, and I will just ditto Member Kasama's comments.
Thank you. Is there any other discussion on the motion? Seeing no other, all those in favor, please say yay.
Yay.
Any opposed, please say nay. Nay. Please raise your hands for the nay. So I have Assembly Members DeLong, Kasama, and Gur as nay. And the motion carries. The floor statement, I will take the floor statement. And thank you, Ms. Drozdoff, if you'll summarize the next bill.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. The next bill in work session is Assembly Bill 188, which revises provisions relating to the Public Employees Benefits Program. The committee heard this measure on April 23rd. Assembly Bill 188 provides that persons hired on or after January 1st, 2012 are eligible to receive a subsidy for health and welfare benefits from the State Retirees Health and Welfare Benefits Fund, subject to certain adjustments and limitations. Additionally, it requires PEB to submit a report to the governor and the legislature that sets forth the typical full cost for retirees to obtain health insurance that is actuarially comparable to state retirees enrolled in PEB. The bill also prohibits the PEB board, unless otherwise required by federal law, from establishing limits on the yearly balance of certain health reimbursement arrangements. The board is further prohibited from reverting money in a health reimbursement arrangement to the retirees fund except under certain circumstances. Finally, AB 188 makes changes related to reinstating insurance. It removes the prohibition that a retired public officer or employee not have more than one period during which he or she was not covered by insurance under PEB to reinstate insurance. It authorizes the employee or surviving spouse to reinstate coverage during any open enrollment period for the plan of insurance, and it provides that the retiree is eligible upon reinstatement to receive the subsidy provided to certain retired employees. Assemblymember Carter proposed an amendment to change the requirements for employees hired after January 1st, 2012, related to receiving retiree benefits. The amendment makes changes to the limit on certain health reimbursement arrangement balances and to insurance reinstatement processes. Finally, it outlines certain topics related to PEB that the Joint Interim Standing Committee on Government Affairs may study and consider for possible legislation. Thank you, Chair.
Thank you. Members, are there any questions? Seeing none, I will now entertain a motion to amend and do pass AB 188.
Second.
I have a first from Assemblymember Carter and a second from Vice Chair Nguyen. Is there any discussion on the motion? Seeing none, all those in favor say yay.
Aye, yay.
All those against, please say nay. Nay. Please raise your hands. I have Assembly Members DeLong, Gur, Kasama, Gallant, and Edgeworth as nay. Motion carries, and I will assign that floor statement to Assemblymember Carter. If we can move on to the next bill, thank you.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. The next bill on work session is Senate Bill 15 in its first reprint, which revises various provisions relating to governmental administration. The committee heard this measure on April 28th. Senate Bill 15 removes the requirement that debt management commissions hold their annual meetings specifically in August. The bill revises the contents of notices of delinquent taxes to specify the tax receiver will issue a certificate at the close of business rather than at 5 p.m. on the first Monday in June. The bill also revises the timing for property reconveyance and quitclaim deed issuance to occur up until the close of business of the county treasurer on the third business day before a sale instead of the current 5 p.m. deadline. Furthermore, the bill provides that county office and branch offices, if any, of the county treasurer may not close earlier than 5 p.m., but may close later than 5 p.m. Finally, the bill revises the posting requirements for franchise notices if more than one unincorporated town is affected, and it removes the requirement for school associate superintendents to provide quarterly reports to county governing bodies. Ashley Kennedy with Clark County proposed an amendment clarifying that county treasurer offices cannot close earlier than 5 p.m. for business transactions on any business day. Thank you, Chair.
Thank you. Members, are there any questions? Seeing none, I will now entertain a motion to amend and do pass on SB 15. have a move from Assembly Member Hunt and a second from Assembly Member DeLong. Is there any discussion on the motion? Seeing none, all those in favor, I will move to the less celebratory aye. Say aye.
Aye.
Any opposed, say nay. Okay, motion passes unanimously. And I would like to assign the floor statement to Assemblymember Karas. We can go to the next one when you're ready.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. The next bill on work session is Senate Bill 27, which revises provisions relating to museums. The committee heard this measure on April 23rd. Senate Bill 27 revises the names of 2 museums of the Division of Museums and History. The bill also revises the powers and duties of the Board of Museums and History by requiring the board to establish policies and charges for certain services provided by the division and its institutions, and eliminating sole authority of the board to take certain actions concerning property received by an institution of the division. Dan Thielen, Division Administrator, and Tom Clark Solutions proposed an amendment revising the museum names. The amendment also eliminates reference to the board relating to establishing certain programs, instead providing that such programs must be deemed proper and necessary by the administrator. Thank you, Chair.
Thank you. Members, are there any questions? Seeing none, I will now entertain a motion to amend and do pass on Senate Bill 27.
So moved.
Second.
I have the first from Vice Chair Nguyen and the second from Assembly Member Carter. Is there any discussion on the motion? Assembly Member Kasama.
I will vote yes out of the committee, but reserved for the floor, just concerned with some of the fees. Thank you.
Thank you. Is there any other discussion on the motion? Seeing no further discussion, all those in favor say aye.
Aye.
All those opposed say nay. Motion passes unanimously, and I will assign the floor statement to Assembly Member DeLong.
Thank you, Chair.
If we can go to the next one.
Thank you, Chair. Alex Drozdoff, Committee Policy Analyst for the record. The last bill on work session is Senate Bill 358 in its first reprint, which requires certain units of government of this state to accept certain forms of payment. The committee heard this measure on April 25th. Senate Bill 358 requires certain units of government of this state to accept from a business entity as payment for any fee, tax, or other debt, payment by debit card, credit card, check, or electronic money transfer. The Vegas Chamber and Clark County proposed an amendment specifying that units of government must accept forms of payment included but not limited to those identified in the bill. Thank you, Chair.
Thank you. Members, do we have any questions? Seeing none, I will now entertain a motion to amend and do pass on Senate Bill 358.
So moved.
I have a first from Assembly Member Flanagan and a second from Assembly Member Karas. Is there any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. Motion passes unanimously, and I will assign the floor statements to Vice Chair Nguyen.
Thank you, Chair.
And with that, we will close the work session. And now I will open the hearing for Senate Bill 285, which revises provisions relating to apprenticeships. To present this measure, we have Senator Daly, and please go ahead when you are ready.
Thank you, Madam Chair, members of the committee. My name is Skip Daly, representing Senate District 13, here to present Senate Bill 285. Senate Bill 285 is meant to give some instruction or guidance to the State Apprenticeship Council when they are reviewing a application to initiate an apprenticeship program and the standards that come along with that. So if you're not familiar with some of the terms, and I know there's some people on the committees that are, when you apply for the apprenticeship program, you submit all of the paperwork you need, and you have to submit what are the standards that you're going to be administering the program under, what is the curriculum you're going to teach, what are the work hours you have to have, what are the classroom hours you have to have, et cetera. And that's what's called the apprenticeship standards, and that's the guidebook that that apprenticeship works under. That has to be, thank you, that has to be approved by the State Apprenticeship Council. So in the past couple of years, the reason we need, I'm bringing this bill, is because there was tax incentives or abatements available on solar work and some geothermal work. Not that we're opposed to any of that, but in order to get the payments, one of the qualifications or requirements was that you had an apprenticeship program. So we had some employers, in my view, instead of doing it the right way, wanted to try to circumvent, jumpstart the deal, and they would come forward and say, we're gonna have the new class of construction worker. There's only 15 national building trades recognized, and there's been 15 national building trades for more than 100 years. The last building trades union recognized and chartered by the AFL was in 1903, which was the Laborers International Union. And all of the work that's done in construction has been under those 15 crafts for over 100 years. There is no new construction classification or term. So this solar worker standards that they brought in had 3 different building trades disciplines within one set of standards. They were trying to have electricians, operating engineers, and laborers under the one set of standards and try to have those workers move from one classification to the next and get interim credentials and do a bunch of things that are not in existing statute, at least in Nevada. So what we're trying to do with this is add a new section 23. Guidance to the State Apprenticeship Council is that if somebody comes in, regardless of what they call it, if they want to have more than one building trade of the 15 recognized national building trades within one program, they can, but they have to have separate standards for each discipline that they're doing. So we had to find the right language. I know some people are busy with other committees and stuff. I know we got the AGC, we got the ABC, NCA, all in agreement and aligned with this, answered the questions for the Labor Commissioner, so they understand it is, and I'll give this example, and I know some of our people understand this. So you have, one of these is painters and allied trades. So under the jurisdiction or the charter that was given by the AFL, so the painters, they cover painters, drywall finishing, they don't do the drywall hanging. They cover glazing and they cover floor covering, at least this side of the Mississippi they do. So they could have one set of standards with all of those internal disciplines, or they could have separate standards for each one, and many times they do. Carpenters, they do insulation, they do lathing, they do Class A formwork, they do cabinets. All of those can be under one set of standards because it's all within the carpenter's umbrella. So when you graduate from that apprenticeship program, you're not going to get a certificate that says you graduated as an electrician. You're going to get a certificate that says you graduated as a carpenter. So that's what we're trying to say. If you want to have one program that covers several different categories, you got to have separate standards for an electrician, separate standards for a bricklayer, separate standards for labor. Can all be covered under the same program, but you have to have different disciplines. So when a guy graduates from each set of standards under that, he's going to get a certificate for whichever classification he was in. So I hope that explains that. There are a few mixed standards that have been approved in the past and various things that cover more than one discipline. We're not trying to unwind the clock. So I believe that's what Section 3 says, is that if you had a set of standards that would be in violation of this provision, that you can continue under those standards for as long as until they're revised or the program ends. But so with that, happy to answer any questions. I hope I explained what we're trying to get to. And like I said, we did get consensus with everybody. The first version had flaws in it, which I recognized right away. Once I saw that, we were able to come to this amendment and get everybody in alignment.
Thank you for the presentation. Committee members, do we have any questions? Seeing none, great presentation. If you'd like to step back, we will move on to testimony. Testimony can be provided here in person in Carson City, via video conference in Las Vegas, or over the phone, and instructions for providing testimony can be found on the agenda. We will begin hearing testimony in support of SB 285 here in Carson City in person. And we respectfully ask that you keep your testimony to no more than 2 minutes, and please go ahead when you are ready.
Good morning, Chair and members of the committee. For the record, my name is Cade Grogan with Ferrari Reader Public Affairs, CADEGROGAN, here on behalf of the Nevada Contractors Association. The NCA is in support of the bill as it helps clarify the apprentice law and would like to thank Senator Daley for bringing the bill. Thank you.
Thank you, Madam Chair, members of the committee. Alexis Motorex with the Nevada Chapter AGC. Also here in support of the bill. Appreciate the sponsor bringing it. It does provide some clarity and maintains the integrity of the apprenticeship programs. Thank you.
Thank you, Chair, committee members. Isaac Hardy, representing Associated Builders and Contractors. We are in support of this bill. Thank you.
Thank you. Seeing no one else step forward in Carson City. In Las Vegas, we see no one at the table wishing to testify in support of Senate Bill 285. So AVH will go to you on the phone lines. Is there anyone wishing to testify in support of SB 285?
To testify in support of Senate Bill 285, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in support.
Thank you. We will then move to opposition testimony. Is there anyone here in Carson City wishing to testify in opposition to Senate Bill 285? Seeing no one approach and still seeing no change in Las Vegas, AVH, we're back to you. Is there anyone on the line wishing to testify in opposition to SB 285?
Thank you. The line is open and working. We have no callers for opposition.
Thank you. Then we'll move to neutral. Is there anyone here in Carson City wishing to testify in neutral on SB 285? Seeing no one going to the table, seeing no one going to the table in Las Vegas, AVH, we're back to you for neutral testimony on SB 285.
Thank you. And the public line is open and working. We have no callers for neutral.
Thank you. Would the presenter like to make any final remarks? Okay, waiving the final remarks, we'll close the hearing on Senate Bill 285. And we will open the hearing on Senate Bill 319, which requires the Washoe County Board of County Commissioners, Reno City Council, and Sparks City Council to establish a board to study the creation of a county fire protection district within certain territory. Good to see you again, Senator Daley. Thanks for staying with us, and please go ahead when you're ready.
Thank you, Madam Chair, members of the committee. Skip Daly again, representing Senate District 13. I'll go through the revised, pared down version of the bill very quickly. We do have the 3 chiefs here. I'll bring them up in just a minute. They can introduce themselves, give their perspective on what we're trying to accomplish and why it's important step forward for Washoe County. And they'll be able to answer any questions if you have as well regarding fire protection services, those types of questions. So the first reprint is now only a study to be conducted by and through an interlocal agreement between Reno, Sparks, and Washoe County to study and present a report with recommendations regarding the regionalization/consolidation of the fire department. The 3 governing bodies are all in agreement with the regionalized fire department. They are all in agreement that a regionalized fire department should be evaluated and as set forth in Section 15 of SB 319. And it found to be in the best and most cost-effective way of providing fire services to the citizens of the region to make recommendations, including requesting additional legislation on how to best implement those recommendations if moving forward with regionalization is found to be a benefit. The 3 governing bodies have to pay any expenses associated with the study. In the amendment I'm proposing, it's basically just a date change. We're proposing to change the date that the report is to be completed from July of 2026 to December 31 of 2026, give them an extra few months. Give them a little more time to complete their work and prepare and ask for a bill draft to come back, I hope, in the next legislative session. And then the rest of the amendment deletes obsolete references to deleted sections from the original redraft. So we had to do a floor amendment at the end, and I think that's how come part of those dates and some of that stuff was missing. It was a personal amendment, was done last day of passage. So with that, I would go ahead and ask the three chiefs to come up, introduce themselves, give a little background information on the goal and why it's important, and then we'll all be happy to answer questions.
Good morning. Dale Way, Interim Fire Chief of the Truckee Meadows Fire Protection District. Pleased to see that there will be a change to the date. I think that's essential. I don't know that we could have gotten that study done within that time frame.
Thank you, and could I ask you to spell your last name, please?
W-A-Y.
Walter White, Fire Chief, City of Sparks, for the record, W-H-I-T-E.
Good morning, Madam Chair, members of the committee. I'm David Cochran. I'm the Chief of the Reno Fire Department. I'm here in support of the bill. I just make a couple of quick comments. From an operational standpoint, I can tell you that a regional department is the most effective, efficient way. I've worked in that system in Washoe County for 12 years. The challenges are with the governance and financing, and our hope is that this study will address those issues and give us a clear path forward to accomplish what we know works operationally out on the ground. So thank you for your time.
That is the conclusion of the presentation. We can move on to questions from the committee. Committee members, do we have any questions for SB 319? Right, seeing none, thank you for the presentation. We will now move on to support of SB 319, and we will begin here in Carson City. Please go ahead when you are ready.
Morning, Madam Chair, committee members, Todd Inglesby, the President of Professional Firefighters Nevada. We want to thank Senator Daley for bringing this bill. We want to thank the collaboration by all the municipalities, the chiefs involved. This study's needed up here. We think this study will not only make it better for our members, but will make it better for the citizens that we serve and we're sworn to protect. Thank you.
Thank you. Seeing no one else coming up to the table in support of SB 19 here in Carson City, and seeing no one in Las Vegas, we will now move to AVH. AVH, is there anyone on the line in support of SB 319?
The public line is open and working. We have no callers in support of SB 319.
Thank you. We will move on to opposition. Is there anyone wishing to testify in opposition to SB 319 here in Carson City? Please go ahead when you are ready.
Thank you, Madam Chair. And committee members, for the record, my name is Thomas Daly, D-A-L-Y, and as a matter of full disclosure, no relation to Senator Daly. On the subject of consolidation of area fire departments in Washoe County, Truckee Meadows Fire, and municipal fire departments of Reno and Sparks, this is an unfunded mandate to do what has already been done. For the record, there are 4 studies, expert studies done over the years, and none of these studies have ever recommended consolidating area fire departments. Those reports include the standard of cover for Truckee Meadows Fire by ESCI, the Washoe County Blue Ribbon Committee Report on Fire Service Regionalization, City of Reno report by the Center for Public Safety Management. These reports did, however, recommend unrestricted automatic aid for fires, and a single dispatch agency, both of which would improve fire service delivery. Further, the Washoe County report on dispatch by the IXP Corporation concluded a single dispatch operation would save area taxpayers $991,000 annually, and that was in 2017. So today, about $1.5 million annually. And we know from Clark County, their experience with a single dispatch operation and unrestricted automatic aid has worked there for 3 decades, while the area fire departments still remain autonomous. So from experts, we know the solutions work, and we know the solutions will save money. Truckee Meadows and the cities of Reno and Sparks have already implemented unrestricted automatic aid, and that will be enhanced in September when a single dispatch software platform is used by all dispatch agencies. It truly becomes automatic. And these jurisdictions are now studying how to consolidate dispatch operations into a single entity. That cost savings measure will happen likely in 2026. So SB 19's mandate for a study is unnecessary because the local jurisdictions have acted. As a retired fire protection consultant, I will tell you this study will cost area jurisdictions $100,000 at a minimum. Listen to your constituents who have overwhelmingly opposed this legislation per the Nellis pie chart. I urge you to defeat this bill and let the local jurisdictions handle this challenge. Thank you.
Thank you. Seeing no one else coming to the table here in Carson City to oppose SB 319, and seeing no one in Las Vegas, AVH, is there anyone on the phone lines in opposition of SB 319?
Thank you. The line is open and working. We have no callers for opposition.
Thank you. We will move on to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral on SB 319? Seeing no one approach and still seeing no one in Las Vegas, AVH, we're back to you for testimony in neutral on SB 319.
Thank you. The line is open and working. We have no callers for neutral.
Thank you. Would the presenter like to come up to make any final remarks?
Thank you, Madam Chair. Again, Skip Daly for the record, representing Senate District 13. Just a couple of comments based on a little bit of opposition testimony that we had. So as you may know, I'm born and raised in Northern Nevada. I've been around for a little while. The three districts, or the two districts, Reno Sparks, were more cooperated and consolidated. There were issues and they got divorced. Variety of different reasons. Service, from what I'm told from every fire professional, was that service and things worked better when they were together. They got the divorce for whatever reason, and then there was a barrier for a very long time with Sparks and having three-man crews versus four-man crews and differences in collective bargaining agreements, et cetera. Those barriers don't exist anymore. So the three agencies are coming back and saying, this is something we'd like to explore. And as the Reno Fire Chief was saying, this is a command and management type issue that they're going to be looking at. They do have interlocal agreements. They do have mutual aid. That's working. They're, whoever is closest to responding to the fire, that's what the service provides, and that's what the three chiefs have agreed in the county and the city in Sparks. But they still have three chiefs. And they still have three training processes, and they still have, three of everything on down the line in the management side of it. And we think there is an opportunity, and if the three governments are willing to do it, we want to facilitate it. I didn't want to leave it open. This has been a discussion for many years, which is why this is said, we're telling you, you got to do it. And it's the first step in the process, and we don't want to let the opportunity go by for another 2 years before we don't get some answers to the questions. And if the answers are that it's not going to work, or it's not feasible, or it's not going to be beneficial, then we'll find that out as well. But I believe the three entities want to move forward and find out the answers to these questions, and I believe in the end it will be beneficial to the service that's provided in Northern Nevada.
Thank you. And with that, I will close the hearing on Senate Bill 319. And I will now open the hearing on Senate Bill 340, which revises provisions relating to governmental administration. Again, thank you, Senator Daly, for presenting the bill. And go ahead when you're ready.
Having trouble with the mic. Thank you, Madam Chair, members of the committee. Again, Skip Daly, representing Senate District 13, here to present Senate Bill 340. So I'll get into what it is we're trying to get done here. Some esoteric stuff here, but I'll be happy to answer questions if it's not explained when I give the presentation. So if you read the digest, I believe it's on page 4, line 147, it states that the Nevada Supreme Court has held, and this is their quote, "Courts should not substitute their own construction of a statutory provision for a reasonable interpretation made by an agency." They're specifically talking about regulations. Until recently, the U.S. Supreme Court held that same position at the federal level in a decision known as Chevron. Basically, Chevron deference, they gave deference to the agency to interpret their own regulation when it came to enforcement and several other things. Recently, the U.S. Supreme Court overturned Chevron and shifted most of the interpretation to the courts. Now, if an agency under its regulatory authority tries to enforce the adopted rules or policy, it can be challenged. Could have been challenged before, but the courts gave deference. Can be challenged by allowing the court to determine whether the agency was expressly granted such authority by Congress. And I think you've seen some of the decisions coming down from the court on agency regulations that they're kicking back to Congress. You can't do this or enforce this because Congress didn't specifically give that to you. And think about some of the things we do here where we say, hey, here's the framework, this is where we want you to go, but you have to put some of this in regulation. We can't put everything in statute. We're authorizing you to do certain things. If we had determinations like that and not having deference in Nevada, I think it would create many problems. By overturning Chevron, the court has created a great deal of uncertainty. I believe that it is only a matter of time before a case makes its way to Nevada, where the litigants will cite the federal case overturning Chevron and argue that our Supreme Court should overturn its previous decision regarding giving deference to regulatory agencies. In Nevada, an executive branch agency can only adopt or promulgate regulation that has been authorized by the legislature to do so. Also in Nevada, by and through a constitutional amendment, a legislative body known as the Legislative Commission has been authorized by law to review and approve any proposed regulation before it can take effect. At the federal level, the argument has been, since the overturning of Chevron, that agencies have to be more specifically authorized by Congress on what an agency can or cannot do. Basically, under this current state where an agency gets challenged, the court has essentially taken control over the regulatory process that properly belongs to the legislative and executive branch of government. Because Nevada's Constitution allows the Legislative Commission to not only review, but to suspend or nullify regulation if authorized by law, SB 340, if passed, will allow the Legislative Commission to interpret the regulatory authority granted by the legislature and to interpret the legislative intent by the regulation if there's a dispute. This authority can only be used under Senate Bill 340 by the Legislative Commission if a dispute that might otherwise go to the court arises, keeping the determination over authority and intent between the legislative, the authorizing branch of government, and the executive, the enforcing branch of government. I know some of you might think that this might be taking away from the executive branch. They might think that as well. But I do not think that is the case. I believe that under the structure of this proposal and as allowed by the Constitution, this keeps the regulatory process in Nevada between the executive and legislative branch as much as possible where I believe it belongs. The executive branch is charged with faithfully executing and carrying out the laws as enacted by the legislature. I think this process will be better for both the executive and legislative branches because in the majority of cases, the executive branch and the legislative branches would be in agreement over the regulatory functions of government, and I believe it will be better for both the executive and legislative branches if the court has a more limited role. As I mentioned earlier, at the federal level, much of the dispute over regulatory interpretation is being held up by the court and pushed back onto Congress, where you know and I know very little gets done. I think it is better to use the procedures available to us under our Constitution to eliminate as much uncertainty in our state, and who better to review and determine legislative intent than the legislature. So I'll go through the bill real quick. I have a copy of it here. I'm assuming you guys will have questions on this one, so we'll see. So section 1 spells out the constitutional authority for this proposal under the separation of powers in Article 3. I hope you enjoyed reading it. It was interesting. Section 3 establishes the process for a person to petition the Legislative Commission to review a regulation regarding an agency's authority and legislative intent. So there's a process on how you want to say, hey, I have an issue with this. Is it within the intent? And they have to submit that. In section 16, sorry to jump ahead, NRS 233B.110, which is in the existing language, allows a person or an agency to request a declaratory judgment from the court. In section 16, subsection 2, this bill amends NRS 233B.110 and allows the court, if they want to order a person or agency to petition the Legislative Commission to review the legislative intent and or regulatory authority. In other words, the court can defer it back to the Legislative Commission. So the proposed amendment just wordsmiths, changes the words a little bit, I think makes it clearer that, and if you, hopefully you have the amendment, and I'll get to it in a second, makes it clearer that there's two processes and that the court can send it back. The other wording was a little awkward when I read it, so I think it's much more clear now on the two-path process. I would like to point out that the Legislative Commission can only use the provisions of this bill if there is a dispute submitted to it for review, either directly or by the court. So they can't go fishing, they can't go out and say, I don't like how this is going. Someone would have to dispute that and bring it to the Legislative Commission. You can see the rest of the review process outlined in section 3. I would also mention here that in subsection 11, and you will see this throughout the bill, that the determination made by the Legislative Commission is not subject to judicial review. Section 4 requires the Legislative Commission to adopt regulations for the administration and consideration of any adjudication process. Section 5 is conforming language regarding judicial review. Section 6 deletes, and some of this stuff is LCB language that we tried to put in this version of the bill under the Sandoval administration that got vetoed. So some of this stuff LCB wanted in there, and that's what some of this is. So Section 6 deletes a definition of what a regulation is not, and as I recall, that came from LCB from AB 403 in 2017. Section 7 also suggested LCB language to ratify the regulations adopted as of February 2025. Section 8 is cleanup language regarding how long an agency has to submit regulations for review. A separate bill put in several years ago tells them they have to put it in a certain time, and it has to be adopted within a 2-year period. Otherwise, we sometimes tell them they have to start over. Section 10 and 14 is conforming language and requires that a copy of the written endorsement by the governor for emergency regulations must be submitted with the proposed emergency regulations. So you can do the normal regulatory process, you can do temporary regulations, and you can ask for emergency regulations. There's time limits and stuff how that has to be done. The governor has to sign off and endorse the emergency regulation. Those two sections just basically say if you're going to put in the emergency regulation, you have to also submit the authorization that the governor approved and endorsed it. Section 11 is also a conforming language. Section 12 is LCB cleanup language allowing for electronic publishing of adopted regulations. Section 13 and 14 is also cleanup language regarding information that must be submitted to the LCB after an agency has adopted a regulation and before review by the Legislative Commission. Section 15, also conforming language. Section 16, in regard to requests for declaratory judgment, is requiring the courts to give great deference to any determination made by the Legislative Commission. And as I mentioned earlier, Section 16, subsection 2 allows the court to order the matter to be sent to the Legislative Commission. And then I think you've seen the conceptual amendment. I had LCB help me with this, which is, I'm sorry again for the lateness of me getting it to you, but I appreciate your latitude there. And I think that's pretty self-explanatory. I was much happier with this version than the previous one. With that, I'd be happy to answer any questions if the committee has them.
Thank you for the presentations. We had a couple of questions and then they were taken off as you answered them throughout your presentation. So thank you. We will now move to testimony. And we'll begin testimony on Senate Bill 340 with in support testimony here in Carson City in person. If anybody wishes to testify in support, please come to the table. Seeing no one approach the table here in Carson City in support of SB 340 and seeing no one in Las Vegas, we will move to the phone lines. AVH, is there anyone on the lines in support of SB 340?
Thank you, Chair. The public line is open and working. We have no callers for support of Senate Bill 340.
Thank you. We will then move on to opposition. Is there anyone here in Carson City wishing to testify in opposition to Senate Bill 340? Please go ahead when you are ready.
Thank you, Madam Chair. Alexis Motorex with the Nevada Chapter AGC. We are here today in opposition to SB 340. It gives too much authority to the legislative branch. It takes away judicial review. This gives the Legislative Commission ultimate authority over the regulatory process and violates the separation of powers that maintains balance and fairness in the existing process. Thank you.
Thank you. Seeing no other opposition here in Carson City and seeing no one in Las Vegas, AVH, is there anyone on the line in opposition to Senate Bill 340?
The line is open and working. We have no callers for opposition at this time.
Sorry for that short, brief, quiet period. We will now move on to neutral. Is there anyone here in Carson City wishing to testify in neutral? Seeing no one approach and seeing no one in Las Vegas, is there anyone on the phone lines in neutral on SB 340, AVH?
Thank you, Chair. We have no callers for neutral at this time.
Thank you. If I could ask the presenter to come up, we do have a question from a member on the committee. Apologies.
Almost got out. Skip Daly again for the record. Thank you, Madam Chair. And ready.
The question is from Assemblymember Gurr.
Thank you, Chair, and I apologize, Senator. But I heard something, and I'm pretty sure I misheard it, but I got to ask the question anyway. Did you say that there would be no judicial review of regulations approved by the Legislative Commission?
No, not exactly. The part that says there's no judicial review is if we go through the process and the Legislative Commission makes a determination after going through the process that it is or is it not within the legal authority intended by the legislature, or that it is not in compliance with legislative intent, or when the agency got the regulation approved, the way they indicated they were going to administer it and interpret it, they're no longer doing that. In other words, people change, heads of agencies change, and they say, well, I think it means this now. Those types of disputes can be brought to Legislative Commission, and if the Legislative Commission then takes it up and makes a determination, that determination would not be subject to judicial review.
Thank you for clarifying that. I appreciate it. Thank you, Chair.
Thank you, and you're a trendsetter, Assemblymember Gurr. Our next question is from Assemblymember Flanagan.
Thank you, Madam Chair, and thank you, Senator, for the presentation. Feels like a heavy piece of legislation, but I guess kind of in line with my committee members' comment, it feels like we are leaning into a subjective space as people might look at issues and review them. And how do we ensure that we're not allowing this subjectivity or opinion of the person reviewing to overreach?
Skip Daly again for the record, and I will attempt, I think I understand where you're coming from. And those are some of the concerns on the whole back and forth of this. So I have to go back to how regulations are promulgated. And as I said, agencies can only enter into the regulatory process if they're given authority to by the legislature. Sometimes it's very specific, sometimes it's very broad, is that the insurance commissioner can adopt regulations as they deem necessary so they can administer the statute, right? So it's very broad. Once we've given them that authority, everything then rests in the executive branch, right? Whether they want to bring the regulation, what they want to put in the regulation, and then they go forward, so then they do a hearing. They invite interested parties in the industry to come in and give comment, and then they have to have they have a workshop, and then they have a hearing, at which point they adopt. So in that process, they can take those comments and make adjustments, but they're under no obligation to. So whatever it is that they want to do with the regulation, they can. Then it gets submitted to LCB for them to rewrite it into the legal language that we get. Then it gets submitted to the Legislative Commission for review. We cannot amend, the Legislative Commission can't amend, you can give it yes or a no. So previous to the constitutional amendment, which was put in by Senator Ann O'Connell, if any of you remember back to Ann O'Connell, because she had an issue in a rural part of the state over a regulation that was put in by a regulatory body, and there was no oversight. And she was concerned that that agency had overstepped their bounds, et cetera, and there was no review process. So she put the constitutional amendment forward. So within that constitutional amendment, the Legislative Commission, or a legislative body is how the constitutional reads, but that's been established and given to the Legislative Commission, can do one of three things if authorized by law. They can review, they can suspend, or they can nullify. Currently, we're only authorized by law to review. The other two portions coming forward to suspend or nullify has to be authorized by law, and that would happen here, but on a very narrow, limited basis. So when the agencies come in and we are under the Legislative Commission's review, Legislative Commission reads it, we look at it. If we have questions, we ask questions. We try to establish how they're going to interpret it, what their intent is. We verify that they're within the framework of the authority that was granted to them to adopt regulations or promulgate regulations. And then is it within the legislative intent? And we've rejected several regulations over this last interim. I was on there, and there were several that I'm going, you guys are crazy, we're not doing this. So at that point, they can go back through the process, make an amendment, or it just go back to the drawing board. But we can't amend it. It used to be, and there was a change that was made in the law, that if there was not an objection, because the Legislative Commission is 6-6, there's 6 senators, 6 assembly members, and right now it's split evenly, 3 from each party. So it's meant to be a deliberative, collaborative process. There used to be if there wasn't an objection, so in other words, it took 7 votes to say no. So we amended that several years back, and now you have to get 7 votes to say yes, otherwise it can't go forward. So under those circumstances, that's how it works now. If we approve a regulation, and it's in the books and it's going there, the legislature, unless we want to try to bring that into statute, and you know how hard that can be, especially if you don't have support of the executive agency or the executive branch, we can put up a bill, we can have hearings, we can propose to bring that, change what that regulation says by putting in statute, make adjustments, but you have to go all the way through the process and get a signature by the governor. So if there's an agency that likes what they have as a regulation and you're not able to get a legislative change, that regulation stands, and we have no authority whatsoever to go back and say, regulatory agency, you should revise this regulation. And they can say, I don't think I want to. If there's a dispute over that, we wouldn't be able to say, no, we're going to drag you back in and we're going to nullify or suspend. Only if there's a dispute would it get into this process. So we're not trying to overreach, I don't think. I know the governor's office is going to think differently maybe. But I'm just hoping we can be ahead of the curve and not have to wait for the Supreme Court to have a case and overturn the deference that we have, and then we have the mess. And I think that doing this now would be better. I don't know if I've answered your question. I gave you a lot of information, but there is, once it gets passed and out of the Legislative Commission's hands, it's back 100% under the executive branch authority. It would take a complaint or a dispute, and if they don't want to come to the Legislative Commission, they can request a declaratory order or judgment, if you will, where they're going to interpret the regulation and the intent, and are they within their purview. They could nullify, they can't suspend or do any of that other stuff. I think the Legislative Commission would have more authority to say, hey, all right, we're going to suspend this part, but not all of it. We're going to suspend it temporarily, give you time to come back with another regulation. Or we would say, we're not going to suspend it, but we want you to come back with another regulation to address the issues that have been brought forward. So I'm not envisioning the legislature taking too much license with it, because generally, we've enabled that agency. We've already passed the regulation. That's why I think we're more balanced. It's somebody outside that says, hey, this isn't the right way, and the legislature would say, no, this is what we intended, and this is how we intended it to be administered. I think this is a better process. I hope that answered your question. I'm sorry if I gave you too much, but.
Great. Seeing no other questions, I want to thank you again for your presentation, and I will now close the hearing on Senate Bill 340. And I believe that ends Daily Day. We will now move on to public comment. Public comment is not an opportunity to rehear testimony in a bill, and we ask that you please keep your public comment to topics within the jurisdiction of the committee. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for public comment can be found on the agenda. To call in telephonically, dial 888-475-4499. When prompted to provide the meeting ID, enter 812-4048-3186, and then press pound when prompted for a participant ID. Each person will have 2 minutes to provide testimony. Please remember to clearly state your name and spell it for the record. And is there any public comment here in Carson City? Seeing no one approach, is there anyone in Las Vegas? Seeing no one there, AVH, is there anyone on the lines for public comment today?
Thank you. The line is open and working. We have no callers for public comment at this time.
Thank you. Our next meeting will be Friday, May 9th at 8 a.m. in room 3143. That concludes our meeting for today. The meeting is adjourned.